Well, good morning, friends. I hope you're all doing well today. Welcome to the think tank. Well, it's a bright and early 4 a.m., so I thought this is probably a good time for me to look at these recordings. Sorry, not these recordings, these documents. So let's see here what I can bring up first. It's going to be a fast one. But that's all good, right? Let me see. I think this is the first one I want. Motion to disqualify. So these are the most recent documents that have come out. Make them a bit bigger for you. And we'll just zip right through this. And then throughout the day, I can see what else is happening elsewhere. So let's see. Motion to disqualify. This is the state of Indiana versus Richard Allen. So what are you guys thinking about all this? How many lawyers do you think this guy has? And oh my word, what is going on in Delphi? Okay, this is 8 pages long. Not bad compared to some of the documents we've gone through. So let's just get into this. Comes now the accused by counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules 12B and D of the Indiana Rules of Criminal Procedure respectfully and moves for recusal of and change of judge from Judge Francis C. Gull. So this is going to be the 2 lawyers that we had for the last almost year. So we know that there's been a problem with a leak and, more than one problem happening in this case. And in my opinion, Francis C. Gull might be one of them. So let's see what we got. Number 1. Under this rule, the judge is disqualified whenever the judge's impartiality might reasonably be questioned regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the term recusal is used interchangeably with the word or term disqualification. 2. A judge's obligation not to hear or decide matters of which disqualification is required applies regardless of whether a motion to disqualify is filed. 5. A judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there's no basis for disqualification. Oh my God, you guys, this case. Hydration, my tongue was sticking to the top of my face again. So, I don't know. Do they go right back and start from scratch? I don't know what the fix is for this particular mess that's been created. I don't think Judge Gall should be in there anymore, I'm sorry to say. And as far as the defense, I don't know how it goes. If Richard wants to keep them, I don't know how that works. And as far as the new ones, well, everything I've read, it's just what I've seen with my eyes on here. I don't know. I'm a little hesitant about these new lawyers too. So I don't know at this point, does Richard Allen get to decide? Those pleadings include the Franks motion filed on September 18th, 2023, the Franks memorandum filed on that date, 3 affidavits. Warren Gallipo, Sergeant Jones, and Sergeant Robinson filed October 10, 2023. In the affidavit of leaker Mitch Westerman, Judge Gall has not removed or hidden any state filings. So that, of course, we know is getting into the Odinism stuff. So the Indiana Access to Court Records Rule 2A provides a pertinent part. All persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that all persons, including members of the general public, the media, and non-commercial entities, are entitled to the same basic level of access to court records. And Rule 4 provides that a court record is accessible to the public except as proven in Rule 5. ACR Rule 5A provides that certain entire classes should be excluded from public access without notice of exclusion, but this entire case has not been declared confidential by statute or rule, and means none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to the records secreted from the docket in this case apply to the above referenced documents, which have either disappeared from CCS or are inaccessible to the public, nor were the documents filed using the procedures required by ACR Rule 5B, i.e., filing on green paper or filing electronically as a confidential document, along with any ACR form identifying the specific grounds upon which exclusion is based. By secreting pleadings from the docket without allowing access to the court record rules, Judge Gall has allowed violations of public access. Because those acts have only shielded documents from the defendant, these actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law, and Rule 2.2, impartiality and fairness. So, what was going on behind these closed doors? Do you guys think that we should have been allowed to see that proceeding as we've been able to see others? Is it like are you guys similar to me where I feel that with everything else that we've been able to see, that it's suspicious that they have not allowed us to see the other day's hearing? On October 12, 2023, Judge Gull instructed appointed counsel to cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed to him by the state and federal constitutions. Now, there also sounds like there should have been an opportunity for these lawyers to plead their case in front of Fran Gull, but she, for whatever reason, has taken another path. And whether or not it's ethical and legal, I really don't know. State to state, as we know, is always different. And I'm not sure. Like I said, I am a little bit worried about some of the judgments she's made. I don't know that they seem like she is definitely not impartial. October 19th, 2023, Judge Gall conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available. She did the same thing after placing his attorneys in an ethical dilemma and again creating a public record outside of the presence of the accused that ignored clear precedent. More liquids. I don't know the legal wranglings that I really don't know how this is gonna play out, friends. Some people are saying it's just gonna get thrown out, or we're heading for a mistrial, or we're giving all of this room for, um, this to be fought. If he if he loses this, she might be leaving a lot of room for appeals, and that's not what we wanna see. On October 19th, 2023, Judge Gall ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case, or to voluntarily withdraw, despite defense counsel requesting clarification as the topics and or motions to be addressed at the October 19th, 2023 hearing. She gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel an opportunity to adequately refute her accusations. And I think that's where they might have she might have one of the biggest fights. She did this without even giving the defense any kind of heads up. And again, no time to fight these accusations. That same day, Judge Gull had prepared statement that she threatened to read to a public, alleging defense counsel was grossly negligent in their representation of defendant Allen. Judge Gull's complaint was more about not having control over counsel. That's sadly the way it's looking, rather than any legitimate concerns that counsel had engaged in misconduct that compromised Richard Allen's defense. A general summary of Judge Gull's complaints are as follows. Yeah, we don't want this to look like she's just trying to push her weight. We want this done properly. So the first one, a judge shall comply with the law, including the code of judicial conduct. And 2, a judge should uphold the law and should uphold and apply the law and shall perform all duties of judicial office fairly and impartially. So I am not saying in any which way that Richard Allen is innocent or guilty at this point. I'm just saying that some things that have been happening in the court seem a bit shady, and nobody needs that. If Ellen is guilty, she's leaving room for him to get off. If he's innocent, there's been a guy rotting behind bars for the last year that doesn't need to be. So a press release, generic in substance, was issued by the defense in November 2022 before the court's gag order and only after repeated press conferences by the prosecution. Ellen's response, the intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over a multiple press conferences by the prosecution. 2 motions filed by the defense, one of which addresses the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed facts that individuals engaging in Norse paganistic practices may have not only deleted 2 girls, but they were also escorting defendant Allen around the prison at the same time his health was in rapid decline. Allen's response, the court had previously ordered the accused transferred to a state prison at the request of Carroll County Sheriff. His mental and physical health began an immediate decline. Prison guards in the area had Odinistic emblems on their uniforms, which endangered their client after the odinistic connection was exposed. The defense had video of the patches the guards admitted they wore. The defense had previously noted a connection between the attacks and Odinism. The patches have since been removed. Mr. Rozzi cited instances of abuse. Those filings were within the obligation established guidelines for effective representation. Mr. Baldwin had drafted an email to co-counsel, but sent it to the wrong person due to self-populating in electronic mail. What? Mr. Baldwin had drafted an email to co-counsel, but sent it to the wrong person due to self-populating in electronic mail. What the hell are they talking about there? Uh-oh. So Alan's response, this was an accident that happens routinely to most people. The intended recipient, attorney Bradley Rozzi, and the unintended recipient share the same first names. Three letters of their first names. The email attachment contained no substantive information, just a bare bones outline of a tiny portion of discovery received by defense in the case. The court has alleged that Mr. Baldwin put improper statements in his Frank's memorandum, not false or misleading statements, just improper in her opinion. Ellen's response, the court had disdain for the defense not filing it under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation, and it again was required by applicable guidelines. Wow. The documents that are coming out right now, it's amazing what goes on behind the scenes, guys. Like, I don't know, are they all shifty looking people? Come on. Sadly, the stuff that's coming out about the Delphi legal system has not been all of that wonderful. So let's hope that it's not all accurate. If they find out that this is crooked, not only will that affect Richard Allen's case, but this will affect all the cases covered by either the judge or the lawyers that are proven to be dishonest. This could end up being a real shite show. That Mr. Rozzi had filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Allen's response, the filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which is often dysfunctional, to communicate with the outside world. Allen had no ability to speak with his wife in private, as his phone calls were all being recorded. That's normal, though, isn't it? As long as it's not his lawyer. I don't know. It's more a question than anything else. Allen's own attorneys were required to make advance reservations to visit him in prison. It is entirely impractical that Allen would have had the means to prepare his own tort claim notice and or secure private counsel to do so. How does this work, guys? Like, is he able to continue with these guys saying that they're going to work pro bono? Are they able to continue? Will this work out that this judge is stepping over? So if Mr. Baldwin had hired a lawyer to represent him in this matter, so yes, he had. Ellen's response: "This was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related unaliving. As a friend and colleague, David R. Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two." The court also alleged undersigned, had put volatile facts in the memorandum regarding possible sanctions or disqualifications. The true facts in a criminal case are often volatile. That was no untruth. The dissemination or leak of the crime scene photos, in which neither Attorney Rozzi or Attorney Baldwin had knowledge nor participated in. Ellen's response: affidavit of Mitch Westerman, previously filed. 9. Guideline 1.1, the Indiana Public Defender's Council Performance Guide for Criminal Defense Representation states their paramount obligation of criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal proceeding. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defenders Association, the National Advisory Commission on Criminal Justice Stands and Goals and Rules 1.1 IRPC. Yeah, if they're willing to do this pro bono, I don't know if she can do this. I really wish I knew. It's so hard. You'd have to study for each one of these, not only states, each one of these counties, each one of these towns and cities. Everything is different. So throughout the pendency of the proceeding, the defense has exposed untruths by law enforcement, withholding an exculpatory evidence by the prosecution, and discovery violations about which Fran Gull showed no concern and did nothing. The court has routinely expressed umbrage at defense counsel's representation through investigations and filings, while silently abiding the prosecution's discovery delays and false statements by them or their agents. 13. On October 19th, 2023, Judge Gull coerced an oral request to withdraw from Attorney Rozzi that did and did not comply with Rule 3.8H, Indiana Rules of Trial Procedures, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in this cause. 14. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. Well, if he's in the shape that he walks around, if that's truly the shape he's in, he's not doing so great. But if it's an act and it kind of looks like it, but I can't tell. What do I know? If it's an act, well, uh-oh. So 15, throughout these proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. 16, counsel for the defendant are appointed pauper counsel, and upon appointed judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail the representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. It has also done so of its own accord without any precipitating motion or request. No due process has been afforded. Again, that's where the defense counsel might have them. Like, she did not give them the time to defend themselves. So I don't know how that's going to fly. Okay, so, boy, okay, we're at 4:43 in the morning, so maybe I can stop drinking pop soon. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably questioned, such as the case in the cause of action, for the reasons described below. Rule 1.2 of the Indiana Code of Judicial Conduct states, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety at the appearance of impropriety. Oh my goodness. Hmm. Do you guys think she's been doing a good job, or are you seeing some kind of lean towards one side or the other? 19, as previously stated, Judge Gall's strong-armed attorneys Rozzi and Baldwin, with a prepared statement that she intended to read into the record, had either attorney resisted her efforts to remove them from the defense. Within minutes, Judge Gall took the bench, started the record, and informed those present in the viewing public that there are extreme and unexpected turn of events, with the defense teams withdrawing from the case. Well, it's not that shocking or surprising if they walked in, she just told them to go away. Judge Gall further stated that the circumstances were clearly outside of our control. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawing this matter. These words run afoul of Rule 2.1 as they demonstrate the tribunal's lack of integrity and impartiality towards the public and usurp defendant Allen's right to competent legal representation. Rule 2.2 of Indiana State Code of the Judicial Conduct requires that a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Well, that's a for sure thing. She cannot pick one side or the other, and she does need to remain objective. That is basically the job of the court, to stay objective and open-minded. So 21, Rule 21.15 of the Indiana Code of Judicial Conduct in pertinent part states that B, a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects, shall inform the appropriate authority. It does not indicate that any such opinion of the court allows removal of appointed counsel without due process, and again, the wishes of the accused. Judge Gall has violated Rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. He signs off and says, I swear and affirm that the penalties of perjury, that the foregoing representations are true. Well. Unreal, guys. Unreal. Oh my God. Are we going to end up with a mistrial? I am so worried about that. These families have waited an awful long time to get justice for these little girls. And if there is shifty lawyers, if there's a shifty judge, if there's shifty prosecution, I mean, if this is the actual case, this needs to be busted wide open. And hopefully we can get these girls some justice. It's heartbreaking. It's going to be 7 years on February 14th of 2024. 7 years that these families have every opportunity got the word out that they needed to find this guy. So if they just grabbed the handiest guy off the streets and decided to charge him and set him up, wah, wah, wah. Anybody involved in that kind of activity needs to go. But if this is your regular run-of-the-mill procedure, although I haven't seen this before, if it's just, it'll be just straight going. If there's issues with misconduct anywhere, I hope it gets dealt with. And then we can carry on with this case. I've been one that has been on the side of, I thought he was guilty, Richard Allen. And, for me, there's doubt. There's doubt. There's too many hidden facts to make any kind of educated determination. And you don't want to guess. What the hell is going on in Delphi? All righty. So this one is order or judgment of the court. State of Indiana versus Richard M. Allen. The court has reviewed the electronic file recently and discovered many pleadings and filings have been marked as sealed confidential and therefore unavailable to the public. The court has consulted with counsel for the state of Indiana and the defense and has discovered the pleadings have been deemed confidential to comply with the court order dated December 2nd, 2022, which prohibits public comment, commonly referred to as a gag order. Counsel agree with the court that the public interest is best served by transparency, but the certain pleadings should remain sealed. Counsel agree that the original unredacted affidavit for probable cause shall remain sealed as it lists names of juvenile witnesses, that the transport order previously entered and future orders shall remain sealed for security purposes, and that the defense ex parte motions and related orders shall remain sealed pursuant to long-established case law. All other pleadings filed prior to the date of this order shall be unsealed and available to the public, except for pleadings explicitly mentioned in this paragraph. Future pleadings and filings that are to be confidential shall comply with court rules. Further, the court has consulted with the clerk of the Carroll Circuit Court about the impact of this order on her office and staff and the public interest in the pleadings of which are being made available. As hundreds of pages of documents are being unsealed, this may create obstacles to the clerk and to the public. To ease the burden of the clerk of the court and to ensure accessibility, the court will make copies of the now public pleadings available at allensuperior.us.delphi, John McCulley. So this was back in June 28th, and this is when they put out that, the most recent, I guess you would say, of documents. That dump that we had. Oh boy, my word, this case. It's like they're picking and choosing what they believe themselves should be out. I just do not want this to go sideways. So this is pro bono appearance for criminal defendant. Court, Carroll County Circuit 1, case number, defendant Richard Allen, defense attorney, lead attorney, Andrew Baldwin. And Andrew, it gives his email address and his address. Attorney Baldwin enters his appearance as Mr. Allen's privately contracted lawyer. Attorney Baldwin acknowledges his prior representation of Mr. Allen as his contracted public defender and reaffirms that he, Attorney Baldwin, did not and has not voluntarily withdrawn from Mr. Allen's case in said capacity. The filing of this appearance is intended to convert Attorney Baldwin's status as Mr. Allen's public defender to Mr. Allen's private counsel, wherein Attorney Baldwin will move forward with said representation on a pro bono basis. In the event that he is not reinstated as Mr. Allen's public defender, with well over 1,000 hours of time spent reviewing evidence, analyzing evidence, preparing Mr. Allen's case for trial, and with the desire to have the court hear suppression evidence, and the desire to get this case in front of the jury as soon as possible in order to honor Mr. Allen's 4th, 5th, and 6th Amendment rights. Attorney Baldwin enters his appearance. Will defendant accept fax service? Yes. Baldwin, Perry, and Wiley. They're not giving up, guys. They are not giving up. So that was Baldwin. That is where the leak came from originally. Okay. And this one, motion to reconsider, comes now. Counsel for Andrew J. Baldwin moves the court to reconsider the erroneous order of the Clerk of Carroll, the removal of appointed counsel. So this is when they were fighting to try and they just wanted her to reconsider. And that's what this motion is about, because they don't want to leave and Richard Allen doesn't want them to leave either. So I don't know. On October 26, 2023, the court issued the following order. Clerk of Carroll County Circuit Court ordered to remove attorneys Baldwin and Rozzi as attorneys of record in this cause. The county clerk is an elected position, duly elected by the people of the county. She or he is a member of the executive branch of government, not the judicial branch. Part of the clerk's responsibility is to maintain a complete, accurate record of court filings. No judge has the authority to overlook the clerk or order the clerk to alter the record of filing. The judge may order sealings of filings only if she complies with access of court record rules which Judge Gull has not. On October 19th, 2023, Judge Gull obtained a coerced and involuntary oral motion of Mr. Baldwin. That withdrawal is a nullity and invalid as not in compliance with Rule 3.8 and 7.0 of the Indiana Rules of Trial Procedure. Mr. Baldwin has never filed a written motion to withdraw and will not do so. By operation of trial rules, he remains counsel of record. So this is the paperwork that they've put out, trying to get Baldwin back in. They want Rozzi back in. And they don't want anything to do with, let me see here. They don't want anything to do with leaving this case. They want to be able to continue doing what they're doing and not delay the court. Verified notice of continuing representation. Okay, let me do. Let's take a peek, guys. We may as well take a good look at all of it before we get another dump, right? Verified notice of continuing representation. So it does sound like the other day in the courthouse, some of the people are saying that Rozzi and Baldwin sat right next to Richard Allen, and the counsel that the court is trying to put in had to sit behind them. So I don't know. It's also sounding like she very much made it clear that these two were no longer counsel. And she wants information to start being filtered over to the other. So why are they good enough to train new counsel but not good enough to be counsel? I guess that would be one of the questions, because they are asking that these guys help basically get these new lawyers settled in and filled in about this case so that everything can run smoothly. So if that is the case, how does she justify doing that? If they're that bad, shouldn't they just be gone? I don't know. You guys tell me again what you think, because I'm not understanding what's going on. And like, this has been such a bizarre case right from the get-go. We don't need more. We just need this to get on the road. And the right people tried. So this is going to be their notice of continuing representation. It sounds like from other people that were in that courtroom are saying that when she's seen Rozzi and Baldwin sitting there, that she just looked absolutely disgusted. They have to figure this out, because this is an ish show. This should not be happening. She's lost control of that courtroom. And I think if they don't just basically scratch her and possibly everybody involved right now, I don't know, because how is this going to work? How are they going to be able to finish this up without having either a mistrial or it thrown out, or, oh my goodness, the appeals. Mm. All righty. So comes now Attorney Bradley A. Rozzi, counsel for Richard M. Allen, and in support of his verified notice of continuing representation, now swears and affirms as follows. I'm going to make this bigger for you guys. So number one, November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Counsel has engaged in continuous representation of defendant Allen since that date and time. October 12th, 2023, the court communicated with Prosecutor McClellan, Attorney Rozzi, and Attorney Baldwin, at which time the court ordered Attorneys Rozzi and Baldwin to cease work on Mr. Allen unless the parties were set to appear in court on October 19th, 2023. The chilling effect of the court's emailed order was to essentially strip defendant Allen of a Sixth Amendment right to represent and essentially disarm attorneys Rozzi, Baldwin, and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court. 3. In an October 17th, 2023 email, Attorney Rozzi requested a conference to determine what we, the court, prosecutor, and defense counsel, are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on record in open court. In response, the court ordered both the defense and the prosecutor to appear in chambers at 12:30 p.m. on October 19th. 4. On October 19th, 2023, Attorney Rozzi and Baldwin appeared at the Allen County Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rozzi requesting that the parties communicate in advance of the scheduled hearing. 5. Attorney Rozzi and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rozzi is of the understanding that the court reporter secured an audio recording of the in-chambers conference, which took place in 2 parts. The court first conducted business as it related to several pending motions by communicating with parties and issuing rulings on said motions. 7. The court then read a prepared statement to Attorney Rozzi and Baldwin, identifying various issues throughout the case, throughout which Attorney Rozzi and Baldwin exercised gross negligence in carrying out their responsibilities as counsel for defendant Allen. The court then suggested that Attorney Rozzi and Baldwin engage in a discussion outside of chambers regarding the allegations. Attorney Rozzi and Baldwin asked for clarification, at which time the court communicated to Attorney Rozzi and Baldwin that there were 2 distinct options. 1, either voluntarily withdraw their appearance and exit the courthouse in advance of the hearing, or 2, participate in the 2 p.m. hearing in the courtroom where the media cameras were installed, the national media was present, and the law enforcement community was seated in the jury box, directly behind defense counsel table, at which time the court would read the prepared statement into record and then disqualify both Attorney Rozzi and Attorney Baldwin in the presence of defendant Allen, and his family and the general public. 8. After waiting approximately half hour, 1/2 of an hour for defendant Allen to arrive at the courthouse, Attorney Rozzi and Attorney Baldwin communicated with defendant Allen regarding the stark choice the court had offered in chambers. Defendant Allen reaffirmed his desire to move forward under the representation of Attorney Rozzi and Attorney Baldwin. So, 1. In October 12, 2023, Attorney Rozzi filed correspondence with the court. Said correspondence contained a letter dated October 11th, 2023, signed by defendant Allen, wherein defendant Allen acknowledged that he was aware of the issues regarding the crime scene photos that were stolen from Attorney Baldwin's office and desired that Attorney Rozzi and Attorney Baldwin continue on with their representation of him. Okay, so 9, after speaking with Mr. Allen, Attorney Rozzi, and Attorney Baldwin, then returned to chambers, at which time Attorney Rozzi articulated to the court that the court had engaged in an ambush of defense counsel, entirely void of due process, and that Attorney Rozzi would withdraw his appearance, but said that withdrawal was not a voluntary withdrawal because the court made it clear that if Attorney Rozzi did not agree to withdraw, the court would publicly shame him in front of the world and his client by forcing him off the case by disqualifying him. I don't know. Is this judge pushing it too far, guys? What an ish show, guys. You know, we've been dealing with this for the last from the beginning of the week, and it's blown up. You know, I'm not all that impressed with the Odinist stuff, and I mean, do I agree with a lot of things that these guys have done? Not so much, but things still have to be done in a proper sequence so that it does not ultimately affect this case. So, number 10, all of the events in chambers occurred without any formal allegations of contemptuous behavior by attorney Rozzi or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints within the Indiana Supreme Court's disciplinary commissions. Well, I don't think, now, I don't swear on this because, again, it's just what I've heard on those YouTube streets, is that these new attorneys have got a reputation. One of them has openly spoke out allegedly about how guilty Richard Allen is. Now, if this is the case, what the hell is she doing? So, in total, Attorney Rozzi and Attorney Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantial finding of a disciplinary action against either. At no time while in chambers did the court ever articulate to either attorney, Rozzi or Baldwin, that their conduct compromised defendant Allen's defense in any way. In fact, defendant Allen himself doesn't believe this to be the case. Well, if we go by what she's done at this point, we are looking at another year before there's even a possibility of a trial. 13, there are no bona fide facts or circumstances where attorney Rozzi engaged in showing that any conduct by attorney Rozzi resulted in negative consequences to the other party, defendant Allen. In sum, attorney Rozzi and attorney Baldwin did nothing to compromise Richard M. Allen's defense. 14, attorney Rozzi's oral acquiescence to withdraw his appearances as defendant defendant Allen's attorney was forced, coerced, and driven only by the circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before disqualifying from representing Mr. Allen. 15, the court's premeditated ambush of the defense placed attorneys Rozzi and Baldwin and the client Richard Allen in the most compromising position. The trial court's stated intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. The public statement and circumstance created by trial court risked tainting the jury pool, harming their client's defense, undermining, their professional relationship with the client, and possibly creating an actual conflict for their continued representation. True. That's all true. 16, the jury trial in this matter is set to commence on January 8th, 2024, a full year and 3 months after his arrest. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case and trial. That's the thing. How do they weigh this? How is this going to be weighed properly? I'm I how am I going to say this? Richard Allen still has rights. He's not been convicted. So what is this doing to his rights. I know many people don't want to think that way, but we have to in order for this to run legally, ethically, smoothly. Okay, so if, however, Attorney Rozzi moves forward with his representation of defendant Allen, there will be no need for two new. That's because it's bloody early, guys. Let's try this again. There will be no need for two newly appointed attorneys to dedicate hundreds of thousands of hours towards a mere review of the discovery, which continues to pour in as recent as late September. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in a shifting of the strategy and approach of Allen's current defense team, which in turn would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rozzi to become familiar with the subject matter in a much more efficient and fiscal responsible way. All these truths weigh in favor of Richard Allen's choice to maintain Attorney Rozzi as his counsel of record. So he's not even asking at this point to get, oh my goodness, sniff, sniff. So they're only trying to get Rozzi in, not Baldwin. So, oh boy, oh boy. So Attorney Rozzi notices up this court of his intention to move forward with a representation of defendant Allen until final disposition of this matter. There is no circumstances under Rule 1.16 of Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rozzi's representation of defendant Eldon, and they are not asking for Baldwin to be continued. There's nothing in here that says anything about that. They want Rozzi back. Now, would they work for Baldwin after that? I can't say. I don't know. But what an ish show, guys. Like, what an ish show. So that's all the new stuff that's come out in the past little while. So I just wanted to get you up to speed with what's going on. We've been doing videos and lives lately, and so much has been changing. And there's lots of conversation about what's been going on in Delphi lately. So there's been lots to look at. You know, we've looked at Ron Logan again. We've kind of touched on Keegan and Tony Klein again. You know, go back to the beginning and see where we started and see if this is where we should be. So go through that playlist, look at the recent stuff, or start right from the beginning. And I mean, you'll notice a difference in the content. Absolutely. I started from scratch, let me tell you. So check that all out. You know, do your own research, and honestly, let me know below what it is you personally think about what has been going on in this case. So I think that's where we are for now, my friends. So I'm going to leave it there. So I hope you are all still having a very nice sleep, cozy in your bed, and I will see you in the next one. Bye.